Hey, I'm attorney Joel LaCourse, and I want to talk to you today about estate planning. Now, many of you may not realize that if you've not executed a document, if you've not done anything for estate plan, that you have an estate plan. And the reason for that is because the legislatures here in the state of Oklahoma have put together laws. And it's true for most states across the nation. And they have defined for you, if you have not put something into place, who is going to receive your estate. And that's done through the process of what's called Probate Court. Now, if you want to be in control of who's going to receive your estate, who's going to receive your retirement benefits, who's going to do all the things that you want to have and how they're going to receive it, then you need to take control of that. And that's by working through an estate plan. Now, the two primary vehicles for that to be done are using a will or using a revocable living trust. Those are two very separate kind of documents, and I want to talk to you real briefly about what they are. A will is a document that you make right now. It sets out who's going to be responsible for administrating your estate. It's going to identify who your children and spouses are, all set that all out, and then it's going to define how and who is going to receive what as part of your estate. Now, the difference between a will and a revocable living trust is that while you make all of those provisions while you're alive, a judge, after you've passed away, is going to authorize that will, because the will has to be done in a certain formality, has to have certain phrases in there, it has to be witnessed by certain people, and it's only after you've passed away and that will is presented to a court through what's called the probate process, will that will actually be executed and your estate distributed according to the terms that you've put into it. Now, because you have to have a judge authorize it, that will now becomes a matter of public record. Anybody can look in the court documents and in the court records and see what your estate is and who's supposed to receive something from it. Now, that's great because you are in control of who gets what, when, and how. But it becomes a matter of public record, and you have to go through a court process to make that happen called the probate process. Now, juxtaposed to that is using a revocable living trust. Now, that's a document just like your will that is made while you're alive. We set out and we create your trust, and that trust becomes valid and appropriate immediately upon the proper execution of it. Now, I liken a trust to kind of like building a house. When you build a house, you build the home and you put the walls and roof and everything on it. But until you start putting stuff in your home, it's just an empty shell. And it really doesn't really serve a purpose. It's just kind of a building on a piece of land. Well, it's kind of the same way with your trust. Once we create your trust, we have to start putting your personal property items inside your trust in order to do something with it later. That process is called funding your trust. Now, after you've created your trust, you need to take the steps necessary to put your bank accounts in your trust, to make sure that your cars and your homes and any other titled personal property items and all your items are identified and transferred into your trust so that upon your passing, there is actually something in there to actually be distributed. Now, unlike a will, after you've passed away, you do not need a court's blessing to have those items transferred out of it. Your successor trustee will simply look at your trust documents, evaluate and gather all of the assets that are supposed to be in it, look at who's going to be paid out of that, and then the net beneficiary, the net estate items that are in there, they will then distribute it according to the terms that you have set out and how you want them to be done. If you have questions about creating an estate plan and what document is best for you, whether it's a will or a trust, man, please feel free to contact our office. We're happy to do a complimentary discussion and interview with you to talk about your estate and what makes the most sense to you. So just please give us a call or contact us at LaCourseLaw.com to set up your complimentary appointment, and we'd be happy to talk to you.